If the respondent is your employee, easy. You can, because you have disciplinary control over him, you can fire that person. Go ahead, IC can carry out the investigation, determine guilt. If the person is not your employee, the Act actually does envisage this specific situation as well.
Hi everyone, welcome back to this episode of the POSHPod. We're in season 2. As always, I have with me Bishen Jeswant.
Hello.
From CAM, specializing in employment law. And I'm Laxmi Char from Parity Consulting, specializing with diversity and inclusion. Today's topic, the complexities which arise when there is an investigation required, but either the complainant or the respondent is not a direct employee. So Bishen, let's get started right from the beginning, right? What if the person raising the complaint, in this case the aggrieved woman, is on a contract with the organization where she's working? And we'll assume that there is no work from home. We'll talk about work from home a little later, but right at the beginning, she's in the office and she goes to the HR folk and says, hey, here's what happened.
Okay, thanks, Lakshmi. So, who is the POSH Act meant to cover, right? The POSH Act, in the objects of the POSH Act, clearly says it's meant to cover every aggrieved woman,
Correct.
right? So, it's not meant to cover only women who are employees. And the Act protects women employees from all harassment, not harassment by employees, all harassment. So the Act is meant to cover complaints from anyone against anyone, right? But there are some complexities. It's not as simple as that, because as an employer, you will only have disciplinary control over people who are your employees. You cannot fire a man on the street, right? You can only fire your own employees. So then, while the Act permits it, how do you deal with complaints from non-employees against non-employees, right? Or a combination of the two. So the Act permits it is the answer. And if we divide the whole world into only employees and non-employees, right? There are subcategories, and we'll come to those subcategories as the discussion goes on, because you can have contract workers, you can have consultants, you can have people who are neither contract workers or consultants, just a salesperson who's visited your office, right? So there can be all kinds of people. So, and again, we break this down into complainant, respondent. Let's start with complainant. That was how you framed your question.
Yeah.
So, if the complainant is your employee, the answer is simple. You have to look at the complaint. If the complainant is not your employee, you can still take the complaint on board as the employer or the internal committee. You can still take the complaint on board. But you have to now look at who the respondent is, right? Is the respondent your employee or not your employee? If the respondent is your employee, easy. You can, because you have disciplinary control over him, you can fire that person. Go ahead, IC can carry out the investigation, determine guilt. If the person is guilty, fire him. Great, right? If the person is not your employee, the Act actually does envisage this specific situation as well. The Act says that when the person is not your employee, you are to initiate a complaint at the workplace of that individual, right? So to take an example, let's take an example here. And in the world of non-employees, let's say that a salesperson has come into the office. I am the employer. A salesperson has come into my office and harassed one of my female employees. The female employee naturally comes to me. I am her employer. She comes to me and files a complaint. But it is against this salesperson who we have no connection with. I can't fire him. I can't suspend him. I can't fine him, nothing. But he has an employer. So I am now to initiate a complaint at his employer's, with his employer's IC, right? And hope then, I suppose, that his employer takes that complaint forward. So there is a mechanism under the Act, is the short point over there.
So that's so interesting. So the employer takes the complaint to the respondent's employer, right? The complainant's employer takes it to the respondent's employer. This is becoming a little PQR and geometry and theorem over here. But when that complaint is handed over to the respondent's employer, basically the woman kind of loses control, right? she doesn't have a further say. So are you saying that the other IC will call the complainant over to their premises and she gets to go there and record her statement? And
glad you asked that part of it as well, because the employer going to, let's say, salesperson, to avoid saying respondent, because we know this example now, a salesperson has come to my office and harassed my employee. I'm the employer, and I have now filed a complaint at the salesperson's employers with the salesperson's employer. This is only to be done if the woman wants, right? The woman can still want for me to deal with the complaint, right? And so then that the next question there is, can I deal with the complaint, right? I said that if I carry out the investigation through my IC, I won't have the teeth to fire that salesperson because he's not my employee. Forget that. Do I still have the ability to carry out this complaint? Because my employee says, like you mentioned, maybe she is not comfortable going into the employer of the salesperson, dealing with that IC, something she doesn't want to do. Fine, she is comfortable only with my IC, and so can I deal with it? Short answer, yes. Right? One, the act does not prevent me from looking into that complaint. Two, there have been case laws. One of them, most recent, earlier this year, the Delhi High Court specifically looked into the jurisdiction of an internal committee and said that internal committee can look into complaints even if they are against non-employees, like the salesperson in our example, right? The court actually was nice enough to go in further and explain how would I then deal with this complaint, because fine, I have jurisdiction, great, so I investigate, I find this person guilty. Now what? So Delhi High Court says an option here is for you, the act says the IC is to submit its recommendations to the employer, right? You can submit the recommendations to the employer of the salesperson. You are still submitting it to the employer. And so that's how the act actually provides for the situation, because the IC can investigate into it and submit recommendations to the employer, the salesperson's employer. And under the act, the employer has an obligation to implement the recommendations of the IC. Sure, it's not a crystal clear situation because the employer conducting the investigation is different from the employer implementing the decision. But the fact is, there is still a framework that we can use. And no court will say that you have a situation where there is no solution. You are trying to make sure that there is a solution, there is a remedy available to employees, and this is the remedy that's available there. There are some gray areas about whether that employer has an obligation to implement. There is a gray area about what if that employer's IC looks into the complaint as well. You now have two ICs looking into the same matter. One finds guilty, one finds not guilty. Which will prevail? Sure, there are some gray areas, right? And we can't address all of those situations, and we'll have to deal with some of those on a case-by-case basis. But we acknowledge there are gray areas, but there is also a solution. So to conclude the point there is that if you have a non-employee, the employer can look into it, the complaint against that person. The report can be filed with the employer of that individual.
So I have a challenge. And this challenge comes from having served on internal committees, right, as the external member. Something that cases require when we are doing investigation is evidence, right? And very often what happens is the presiding officer of the IC writes to a particular authority. The authority could be, for example, if the presiding officer says, I want the emails that were sent, in this context, right? She, because presiding officer is a woman, she writes to maybe the head of IT and says, please extract it from the server and give it to me. So there are operational requirements that the presiding officer, goes through. In a case like this, where the aggrieved woman belongs to X company, the visitor, the salesperson belongs to Y company, and there is an investigation that's happening, there could be issues where perhaps Y company, going back to the letter and the spirit, right? Y company says, write as many letters as you want. There's nothing that mandates that I have to send you this information.
But there is. There is, because the IC under the POSH Act has the powers of a civil court with respect to two things, which is calling upon evidence and calling upon witnesses to give testimonies.
Yeah.
So if an individual chooses not to give evidence or chooses not to testify, that would be contempt of court. Right? So the IC has the powers of a civil court in these regards. So there is no opportunity for an individual or an employer to legitimately say that I am choosing to ignore your requests. They can't, because they would effectively be defying the court.
And then the second challenge is if we flip it around. So in this case, I'm the employer of the woman, and therefore I'm, kind of all fired up, and I need to protect my woman and go ahead and investigate. But if I flip it around and somebody else comes to me and says, hey, your employee who happens to be a man, a salesperson, went to someplace else and they've done the investigation, and they have found my employee, who's the respondent in the case, guilty, and that IC tells me fire the guy. No, why should I?
Yeah, so that's exactly the gray area I was talking about earlier. The obligation of the employer to implement a decision given by some other IC.
Yeah.
Right? So I would imagine here, if this situation were to play out, that this employer would have the opportunity to at least review and determine whether the investigation has been carried out in accordance with the principles of natural justice, whether parties have been given a chance to be heard, whether parties have been given a chance to adduce evidence, cross-examine witnesses and all of that. And if the process has been followed, and I as an employer who has now received a report from another IC don't see anything wrong with it, I would imagine that you would have to implement it. Because the other option there would be somebody will go to court and challenge it, right? That is, the other employer or the IC will challenge it, saying there's a non-implementation issue over here. At which point I may not have a leg to stand on to say that I am not implementing it for these good faith reasons. But if on my assessment I have found that opportunity for hearing has not been given, a witness has not been presented, etc., etc., I may at least have a leg to stand on to defend my position, right? So not straightforward, but I would say that if the IC has carried out the investigation properly, even an outside employer, third-party employer, would have an obligation to implement those recommendations under the POSH Act. Because if we don't see it like that, you're effectively having a lacuna in the law with an IC carrying out the entire investigation process for no purpose, right? Which cannot be the way a law is read. So while not clear, this is the logical way I would say it has to be read. Since we are here talking about respondents, right? Let's talk about some of the various kinds of respondents, because in today's changing workforce scenarios, you can see that a lot of the world will move towards in the future a situation where a lot of your workforce is not comprised of your own employees.
Yes.
Right? You would have, in today's world, you see housekeeping staff, security staff are not your employees, right? You go to a third party vendor, you may be familiar with companies like G4 Securitas or TAN who provide housekeeping and security services. And that's become very common now. You don't hire security guards and housekeeping, you go to a vendor and agency and have manpower supply contracts with them. But going forward, you will find not just these ancillary services, but your primary services, like if I'm an IT company, my software engineers may also be engaged through a vendor.
Yes.
Right? And it's happening already.
Yes.
As we go along, you will see it happen in larger and larger numbers. So you will see situations more and more where these complaints of sexual harassment are from and against people who are not your employees. And employers cannot be surprised by that when it happens in the future. It is going to happen. So you need to prepare as an employer, know what the law is around it, and what can I do as an employer to prepare myself for those situations, right? And so, one, the law we discussed earlier, if the complainant, let's say the complainant is my employee, I have to do the investigation if she wants me to. But if she is open to having an investigation in my vendors, with my vendors IC, that is an option that I should have envisaged. So how do I envisage it? By putting it in my contract, right? Because the law doesn't clearly say how the situation must pan out, right? We are using a couple of sections of the law along with what the Delhi High Court has said to arrive at a conclusion on what happens here. But we can give further teeth to that by putting it in the contract. So when I go to a company and engage software engineers through them, my contract with them can clearly say, if there is a complaint against sexual harassment complaint against your employee, you will deal with it as long as my complainant is fine. Or if your person complains against my employee, I will deal with it. Considering the workplace, the workforce is moving towards a world where a large part of the working population may be non-employees, contract workers, the way we discussed, that employer may go out to a vendor, engage manpower, even to perform core work like IT software engineers, right? And there would then be a possibility and a good chance, I would say, in the future that the complaints that come up are from and against contract workers, right? So you can't at that time be surprised that and you don't have a policy in place and don't know how to deal with this because, oh, I was expecting this to be only against employees. Because we are talking about it already. The world knows that you're moving in that direction. You should have been prepared. And so how do employers prepare for that? So like we discussed, the law allows you to undertake complaints by non-employees as well. But it's not written in crystal clear terms. We are using some words of the law. We're using language provided by courts to arrive at a conclusion that, yeah, we can look into these complaints. If the woman employee who's filed the complaint is okay with it. So, but there is an additional avenue, which is also a legal avenue, which is the contract between the parties. And the contract I'm referring to here is, let's say if I'm an employer, I would have a contract with another company, a vendor or an agency to provide manpower to me, the manpower supply agreement or a services agreement as we refer to it. So that is the agreement which would be the right place for the employer and the vendor to decide what the terms should be in relation to dealing with sexual harassment issues. If the complaint comes from my employee against the contract against a contract worker, then the contract worker's IC should deal with that complaint. If it comes from the contract worker's employee against my employee, I should deal with that complaint, right? Or if both the complainant and the respondent are the contract worker's employees, the contract worker should deal with that complaint, etc., etc. And all of this, of course, is ultimately subject to whether the complainant is okay with either party dealing with it. Sure, but all of that can be built into the contract. And the point here is that employers need to foresee these situations and include such terms in the contract. And why is it important to be in the contract? Because at least in that situation, even if the law is not clear, if the contractor, that is the vendor, does not do what he's supposed to do, there will still be one more recourse in terms of breach of contract, right? So there is a law which provides for it, courts support it, and then there is also a contract which puts an obligation on you to carry out the process in a certain way. So that's the way in which employers are starting to deal with these situations and should do so more and more.
But again, talking about the complexity and the operational models of the workforce, right? If there is a master services agreement between two organizations and contractors from each of these organizations are working with each other, there's also the other element when you said that employers need to be kind of forecasting these kind of issues. And I'm bringing it back now. The POSH Act under employment law is one of the very few acts which actually has a very broad definition of the word employee, right? Most of the other employment laws are pretty specific about who they cover. So does that mean that employers need to also perhaps look at the language in their service rules or look at the language in the employment contract that they use with their own employees as well as maybe independent contractors?
See, the POSH Act allows non-employees as well, right, to file complaints with you. So if an employer looks to restrict the ambit of the POSH policy within the organization to say that I will only accept complaints from employees who are my employees, right, that is a violation of the law. And such a policy, if challenged, would not stand up in court, right? Because you are not doing what the law obligates you to do. Because if I say that I will only accept complaints from my employees, and then I have a visitor who has come to my office who's been harassed by my employee, and I refuse to take on that complaint, saying that even though the accused is my employee, the complainant is not, and my policy does not apply to her, that would be a violation of the law. So I cannot do that, right? And the law very clearly says it is meant to protect an aggrieved woman.
Mhm.
The law does not define a woman, right? But it defines an aggrieved woman to be someone who is employed or not employed, right? So the law is extremely clear. So there is no opportunity here for an employer to choose not to undertake those complaints. Lakshmi, we discussed contract workers because that's the most common model going forward. But I also want to touch upon briefly people with whom you have no relationship whatsoever. Initially, we discussed non-employees such as salespersons. They at least do have an employer whom we can go to, right? We discussed contract workers who also have an employer, that is the vendor that we are engaging them with. But there could be people who have no employer, such as a consultant that I have engaged. He's not my employee and he's nobody else's employee, right? We could have gig workers, right? Like Swiggy drivers, Zomato drivers. They are nobody's employee, right? And they may come to my premises. Right?
That's a little, moot, right? In terms of the employment contract or the employment status of Swiggy and Zomato delivery.
It's not moot because in every relationship we are looking for somebody with the authority to take action.
Yes.
Right? In the salesperson situation, we are hoping his employer will take action. In the contract worker situation, where we have software engineers who are not my employees, we are hoping their employer, that is my vendor, will take action. With Swiggy, Zomato drivers, there's no one to take action. With consultants, there's no one to take action, right? But all we can do in that situation is see, do we still have some authority over them, right? Does it still make sense to carry out the investigation, right? For consultants, we do still have some authority over them. We can still terminate their consultancy contracts.
Yes.
Right? So to that extent, it still makes sense to carry out an internal investigation as an employer, even though he's not my employee or anybody's employee. So what we have to look for is, do we have some relationship where we can take some action, even if they are not an employee? And I think that's an additional category of persons whom employers need to think about.
That is so interesting. So basically, an employer needs to think about everybody out there who could at any point in time come into contact with their employee. Wow. Okay. So in the list of employer mandates, we've just added one more. Hey, employer, have the visibility into the future and figure out how this world is changing and the ambiguity of it all. All right. That's a lot of work and a lot of thinking that we need to do. So while I go away and wear my thinking hat and kind of mull over everything that you've shared with us today, Bishen, for all the viewers, thank you for sticking with us. We hope that you found this episode interesting. We'd encourage you to come back, please, and go ahead and look for us in season 1, where we, in fact, referred to some of the points that we spoke about today. But do like, subscribe, and share this podcast with anybody that you think would find it useful. Thank you, everybody. Thank you, Bishen.
Thanks, Lakshmi. Thank you, everyone, for watching.